6A6 Agreement of the non-public residential facilities. Requirement of the contractual agreement. Each school district shall provide special education related services to exceptional students with disability through contractual agreement with an approved non-public school community facility under the following circumstances. When the school district has determined no special education offered by a cooperating school state agency adequately provided the educational program for the student and or for the precision educational component of the residential placement exemption of a student with a disability, such is made with another public agency. Primary purpose of addressing residential or non-educational needs in accordance with subsection 3 and 4, subsection 1003-57 for state statutes. The student involved in the educational plan developed in accordance with 6A603028 of the Florida Administrative Code may reflect the residential placement is not required in order for the student to benefit from the special education which could otherwise provide to the school district during the day. Each school district may provide a special education related to services to exceptional students with disabilities through contractual agreement to approve non-public schools, community facilities, provisions, non-residential interagency that includes the provisions of educational programming in accordance with student individual education plan. The calibration of the Part C early steps program. Each of the school district may provide an early intervention services for an infant, toddler, or disability through the contractual agreement of approved non-public community facility. The school district determined the non-public community can be appropriate services with the infant and toddler. Earlier intervention shall be provided in accordance with individual family support, IFSP, individual family support developed in accordance with the Rule 6A 6.030.029 Florida Administrative Codes. Contractual agreements with non-public schools and residential facilities. The requirement of the subsection does not apply when the school district's educational assessment and a program instruction special education service and student in custody department of the juvenile justice who served in residential and non-residential facilities, juvenile facilities located in the school district in accordance with section 1003-52. Okay, placement in residential facilities, students with a disability, a public agency, other school districts in accordance with subsection 3, the 1003-57, and an exceptional student is with a disability may be placed in a private residential care facility, the Department of Children and Families Agency, the person with disabilities, agent with healthcare, agency for healthcare administration. For the purpose of subsection placement means the funding arrangement funding by agencies part of the cost of the exceptional students for the disability reside in the private residential care facilities placement crosses the school district lines. Um, Continuing with contractual agreements with non-public schools and residential facilities. Private residential care facilities, residential facilities that is operated, licensed, regulated by the public agency shall ensure that 10 business days of the student disability placed on the facility written notification placement to be provided with the school district written with the current written with the student enrolled and counted with the funding purposes such under section 1011-62 sending school districts the school district where residential facilities is located receiving school district is the student is not currently counted for the funding purposes. The school district is in which the legal residence of the student located. The school district in which the legal residency of the student is located as shall be notified the residential facility in writing in the required timeline. The placing agency shall be calibrated the residential facility to determine how the notification will be provided with the required timeline. See, in accordance with the subsection 3 of the Rule 6A60334 Florida Administration Code, sending the school district shall take responsible for properly responded residential facilities requesting the transmittal of the student's educational records. Student placement of the residential care facility occurs with the notification procedure regarding the payment of the pending. The student shall remain in the enrolled sending of the school district. The sending school district shall calibrate with the residential care facility to ensure that the student receives the free, appropriate public education, special education related service, including services comparable with those described in current and individual education plans, until notification procedures regarding payment are completed. Each school program is responsible for assuring the proposed program in non-public and community facilities appropriate to meet the educational for the exemption of the students with disabilities, early intervention needs of infant and toddler disability placed on a contractual agreement subsection constructed with the limit to the responsibility of the agency, state, of the other district school boards for providing paying of the sum of all costs for the free appropriate public education and early intervention services to provide children with disabilities ages birth through 21 years old. Before a contractual agreement with a non-public school, the community facility is executed with the school district. The school district shall be determined the school and community facility meets the following criteria. The non-public school for the community facility is staff and the qualified personnel defined in 6A10503 Florida Administrative Codes. Appropriate licensed entities, personal in and out of state of the non-public school community shall be certified and licensed in accordance to the standard established in the state of the non-public school community facilities is located. For an appointment of the person not certified instructional personnel in the governing body of the non-public and community facility shall be adopted the policies under the Rule 6A10502 Florida Administrative Code. The non-public schools community facility instruction school day year shall be consistent with the section of 1011-61 Florida State statutes, taking into account of the number of the school hours of the school days provided in the school district. The non-public schools community facilities maintains the current sanitation, health kit certificates, fire inspection for each of the appropriate buildings when will open an inspection appropriate authorities. The number of public schools community facilities that complies with the school district procedures to protect the confidential student records information ensures that it provides the parent and students right with the transfer and reaching the age of the majority of the age 18 with right of the access to copies amendments hearing the specified 6A10955 Florida Administrative Codes. Non-public school community facilities will designate a staff member to the responsible administrative provisions contracting for supervision and educational program provided to each of the student and early intervention services provided with each child age birth through 2 and under the contract. Non-public schools community facilities have written procedures, admission, dismissals, separations, and students if appropriate. The non-public school community facilities have been written. The description supported services that are available to provide the student placed under the contract in accordance with student's individual education plan or each child's IF in something family support plan. The non-public school community facility has written policies concerning the care of the student, emergency clinical administrative records, personal policies, staff duties, fee schools, and services insurance coverage. The school districts are determined the non-public school community facility in compliance with the United States Department of Education and Civil Rights have requirement to inspect the non-discrimination, no matter the related to the color, national origin, Title 6 of the Civil Rights of 1964, Disability Title 2 of the American Disability Act of 1990, Implementation Regulations, Title 28, Code of Federal Regulations, Part 35, Section 501, 504, Rehabilitation Act of 1973, and Implementation Regulations, Title 34, Code of Regulations, Part 101. Sections under the Title IX Educational Amendments of 1972, age under the age description in 1975, Fair Access Facilities of the Boy Scout American Equal Access Act, Section 9525 of the Early Elementary Secondary Education Act of 1965, as amended by the No Child Left Behind 2001. The non-public community facilities have reported with the Department of Education as prescribed in Section 1002-42 Florida State Statutes, contents of the contracts between the district school board, non-public community facilities provided with the educational programs as exceptional, a student with a disability, early intervention services, a child with disability, birth through 2 shall not extend to the beyond the school district fiscal year shall include the lease of the following: written assurance of the non-public school or community facility staff, the qualified person defined in the Rule 6A 1.0503 Florida Administrative Code is appropriate identified in licensing and etny. A description of the scope of the service provided by the non-public community facility, how it relates to the individual education plan, an exceptional student with a disability or individual's family support plan, infant and toddler with a disability, provision and reporting appropriate school district, personal or in parent student progress, and the meeting of the annual goals in accordance with the individual education plan for the child's support progress, and the meeting of the major outcomes of the individual family support plan. Provisions of the appropriate school district personnel to review the program provided by the non-public or community facilities conferred with the staff of the non-public community facilities at the reasonable time. The provision of the reporting appropriate school district non-attendance with exceptional student with a disability, infant, toddler, disability, provision of notifying appropriate school district's personnel as the parent using the section of restraint to the student in accordance with Section 1,350-573. The method of determining charges sharing the cost other than agency plan under the contract, including the project total cost of the school district. H. Identification of financial responsibility. The method of resolving interagency disputes. Such methods may initiate the district school board to secure reimbursement of the other agencies. J. A schedule the review of the program being provided the exceptional student with a disability or infant toddler with a disability through the contract. Provisions of termination of contract allow written assurance of the non-public school community facility compliance with the applicable provisions, Civil Rights Act of 1962, Title IX of Education Amendments 1974, Section 504 of the Rehabilitation Act of 1973. Written contracting non-public school common facility in accordance with paragraph 1A of the rules. School district shall be responsible for the lease of the following: selecting an appropriate non-public community facility, consolidation, parent and other appropriate personnel to be provided transportation of the student age 3 through 21, maintaining a case of the including progress reports, period elevation, period evaluations, exceptional students with disability, infant and toddler disability, verifying exceptional student with disability, the infant and the toddler who is determined eligible for the Part C Early Steps program is a resident of the school district or and enrolled and has made an application admits to the school district program. Either provide the cost of the student educational program to intervention services are specified as contract. Maintain documentation of the qualifications of personnel of non-public school community facilities as required by the rule appropriate licensing, including the outfield notification requirements of Section 1012-42 Florida State Statute, providing appropriate educational programs to the student in its least effective environment. The annual or more frequent review of the student's individual education plan, earlier interventions. Services in a natural environmental based 6-month more frequent review of the child's individual family service plan. Maintain copy of the individual educational and individual family service plan in the school district, providing copies of the individual education student plan with the residential placement of the Department of Education Bureau of Exceptional Education Student Services, reporting data collection, monitoring the essential seclusion of the restraining of the student according to Section 1003-573 Florida State statutes. With exceptional students of the disability, infant, toddler, disability enrolled in a non-public community facility on contract or arrangement, providing the special education program, the intervention systems, intervention services are provided here, and the student, infant, toddler shall generate the Florida Educational Finance Program, FEEFF. Florida Educational Finance Program funds of the school district appropriate the cost categories established in Section 1011-62 Florida State statutes under these conditions. The non-public school community facility program meets the criteria established in subsection 4 of this rule. Students regularly attended in the program the length of the school day, minimum number of these days, have been compliant with 6A1045111 Florida State statutes. As student appropriate with identifying exceptional student with a disability school district, infant toddler determined the eligible infant toddler disability of Part C earlier steps programs required with Section 1003-013A, 1003-57-1B, Florida State Statute rules of 6A6-03011 and 6A6-03411. Florida Administrative Codes does not include the students who are gifted defined in 6A6-03019 or 6A6-03091. Individual education plan and the IFSB student plan developed as required in subsection 6 of 6A6033331. The full-time equivalent student membership of this exceptional student is disability infant and toddler student under the contractual agreement, including the school district reported the membership annually prior to the first report. Full-time equivalent membership of the student residential plan is made in the non-public schools community facilities. A copy of the contracts may be all participating parties in the files of the Department of the Education Division Public Schools Bureau. The Exceptional Education Students through services through 325 West Canyon Street, Tallahassee, 432-399-0400. When a school district contracts the educational component of the residential plan in place with a group of students, one contracts the student names of the individual contract shall be filed. When an exemptional student with a disability is offered in the appropriate educational program, the school district shall pay with school district and parent weighs the opportunity to favor the program selected with the parent, and the parent shall assume the full financial responsibility of the student education. The rulemaking authority is 1001-02 Florida State's law implemented 1003, 571, 1003-58, 1011-62. Florida State Statutes History News, June 17, 1974, repromulgated in December 5, 1974, and in March 28, 1978, amended in August 8, 1978 and July 13, 1983, formerly 6A6361, amended in February 18, 1993, and May 15, 2011. And that is the 6A videos.